Jamaican lawyer Paula Llewellyn, also the director of public prosecution, had a lot to say about Vybz Kartel. Welcome back to my channel, More Life, More Strength. Hope you guys are feeling well. So Isaac Buchanan, Vybz Kartel lawyer, is looking forward to argue his appeal this year. So you know, before the year done, Vybz Kartel I gonna know him fate. Either I'm going to spend more time in a prison or I'm going to follow that road. Either way, news circulating on Tuesday that the Privy Council denied the application for leave to appeal the conviction and sentence of Vybz Kartel, you know, for the 2011 murder of Clive William. However, the Office of the Director and Public Prosecution subsequently brought clarity through a press release. So in this video, she explained what really happened and why did the two findings or new evidence did not grant access. The last video I did on this topic, I mentioned the fact that Vybz Kartel, previous lawyer, did not do much, and based on this lady reasoning, it seems like she's saying the exact thing, you know. But of course, she now come out as strong and mention those words, but she's saying that those evidence should have been exercised from the first trial. In other words, at this stage, it's difficult for bringing such evidence. So whoever did represent Vybz Kartel should have made the expert them conduct this test long time. Here's the thing that you need to understand. Once there's an appeal or court of appeal like Vybz Kartel situation, and I like say our exact trial or go on, you know. It's more like whatever findings them have or the grounds with them charge him for, and them go over that and exercise and ensure say everything did up to par during the trial, as in the law itself, them abide by that. So now you might understand why the cell phone never really makes sense or why them never grant access to that. If you don't understand, look at it this way. It's like remarking a paper. So the paper, the exam paper would be the trial. Whatever them write on the paper, that would have been Vybz Kartel or the lawyer them findings, and I mean the case of them present itself. So the court of appeal is just basically remarking that paper. To put it simply, appealing a case meaning asking a higher court to review a decision made by a lower court. So right now we are all waiting on whether or not his conviction will stand or be overturned. Boy, this man should have been the first lawyer star. Yeah, because right now man them tie up, you know, nobody not really a point that out, but his hands are tied. The case really rely on the first lawyer. The good thing about this appeal, no string attached whatsoever, no feelings, none of that. You know, I say just some judge I gotta review the case and listen what Isaac have to say and the other person. Fingers crossed same way. I mean, if you remember the case, we know say a whole heap of effort one. Whole heap of run around and we don't need to go through all of that. Sure no son remember the case. Anyway, listen to what Miss Paula had to say.
What is this happening here now? Because there's a lot of short things that happen. Say, boy, I'm now going to come out of jail now because they refuse this and refuse that. So you are the best person to...
Well, the thing about it is, I'm just a humble, how should I put it, prosecutor who is going to make an attempt to explain. The thing is, you know that Mr. Palmer and other persons were convicted of murder at the trial. Then the matter went to the appeal court. They appealed conviction and sentence. And you had many days of arguments between their lawyers and lawyers for the crown, for the prosecution. At the end of the day, the judges upheld the conviction and sentence. However, there were arguments in law where their lawyers sought to persuade the Court of Appeal to give them what we call leave to appeal to the Privy Council in England. The Privy Council, according to our structure, legal structure, is still the highest appellate body for Jamaica and allow them to appeal to the Privy Council. Now, along the way, while the matter is there waiting to be heard in England, before the Privy Council is there, the lawyers in England and here for Mr. Palmer and the other accused asked permission of the court in Jamaica for the cell phone, which is at the heart of the Crown's case, the cell phone belonging to Mr. Palmer, to be examined by their expert. The court here granted that permission on the condition that the cell phone is to be examined in the presence of the expert, the cyber expert, prosecution. So they were able to examine the phone. So what they did is sought leave from the Privy Council, and they did this in writing. So at the Privy Council, at the Court of Appeal here too, you have to submit written submissions. Then the Privy Council now will decide whether they need to hear from you. So written submissions were submitted by Mr. Palmer's lawyers, as well as the lawyers in England for the Crown, to do what we call adduce fresh evidence. That is fresh evidence from the expert, their expert who examined the phone. And also, they decided to seek permission of the Privy Council to advance or to argue additional grounds that they didn't argue in the Court of Appeal in Jamaica as part of their application for leave, permission to go to the Privy Council. So, detailed submissions were submitted by the lawyers for the appellants, as Mr. Palmer and the others, as well as lawyers for the Crown. And we have English barristers as well in England acting for the Crown. And so the Privy Council, having considered the written submissions, decided to refuse the application for leave to adduce the fresh evidence. That is the evidence that they wanted to bring before the Privy Council to try to establish that there was some improper interference with the cellular phone of Mr. Palmer while it was in the custody of the police. So they refused permission to do that, and they also refused permission for his lawyers to advance additional grounds of appeal in respect of which permission had not been previously granted by the Court of Appeal in Jamaica. So with that, there remains the substantial appeal against conviction and sentence, which will be heard by the Privy Council at an appointed date.
All right, so I'm going to ask you a question. This thing around the cell phone was what Adidja Palmer lawyers was wanted to advance in the court, and they passed that already in the local court. The local court did already throw it down.
No. So what happened? Remember, the prosecution centered a lot of its case on the contents of the cell phone, the voice notes, and that sort of thing. Yes. So at the Privy Council, I mean, this thing has gone now. It has gone through Court of Appeal, and at the Privy Council, his lawyers now wanted permission to adduce what we call in law fresh evidence. So whatever the expert found and has put in a report, they wanted to be able to call the expert who would swear on the Bible or affirm, as the case may be, and give that evidence to the Privy Council up there, or put the written report before them. So that is what they refused, as well as additional grounds that they had formulated.
So you have any idea what the new evidence would be or could be?
Well, what would happen, is that written submissions, perhaps it would be what the expert found, but written submissions of this would be put before the Privy Council. And the reason why it was not available at the time of the trial. Because there's a concept in law called fresh evidence, also at the appellate court in Jamaica. So for it to be able to pass muster, it would have to have not been available at the time of the trial. And it would have to be credible, basically. So it is for the Privy Council, having looked at the written submissions, to decide as a matter of law whether they could give that permission as a matter of law. Because remember, Mr. Mutabaruka, when we're dealing with law, some people think that the law can be an act, but when you're dealing with law, it's an objective situation. It's not about how you feel or whether the person who is appealing is popular. It's about what the case law that has been decided over the years, what it has to say on the point, and the material that the lawyer, whether for the Crown or for the defense, is going to put before the Privy Council to say, this is why, and this is the case law that supports that. So they looked at all the written submissions and they refused those applications.
What Adidja Palmer lawyers are asking for, is there a precedence to that they could bring to the Privy Council or the court down here?
Well, if you're looking at the concept of fresh evidence, it's a concept known to law. The concept of fresh evidence, it's a concept, well-known concept known to law. But the thing is, whether the material or what they're seeking to advance as the reason why they didn't put it forward before, or of what import it's going to be in the scheme of things, it's whether, as far as the judges are concerned, it is justified by the case law, or whether the case law can be cited to justify them. If they don't find that the case law, the objective case law, and the material presented, that it match, then they are not going to allow you.
Okay.
It has happened here in Jamaica.
So what will happen now? What will happen now?
What happens? They having refused these applications. The main substantive appeal now against conviction and sentence will be heard by the Privy Council at a date that they will set. You understand? So it is substantive appeal now, where they are saying, based on this evidence, based on this particular ground of appeal that we are advancing, we should not have been convicted and we should not have, and therefore the sentence should be set aside. So what they want is for the conviction to be quashed and the sentence set aside. But when you are in the appeal court, it's not a trial of the case all over again. Right? Like when the jury sit and hear the evidence and hear the witnesses give the testimony and hear cross-examination, that is not what happens on appeal. On appeal, it's all about the law. Right? So you will have about 5 judges at the Privy Council who will sit and listen to arguments in law, looking at the circumstances of the evidence that was put forward, but arguments only in law would be made by the attorneys, the lawyers for both sides, both for the appellant and for the crown. And
so is there any time granted this thing would proceed or continue, or I'm have to sit down there another 7 years to find out?
No. I mean, the thing is that I would think somewhere before the end of the year.
Okay.
That may be set for their calendar, because remember they have other cases that they have to hear from other countries in the Caribbean, from countries in Asia. They have other cases that they have to hear. So they are the ones who set the calendar, and then they notify the lawyers on both sides.
Well, you have made it clear. I mean, you said better than if I did just read it off on the paper. So
okay.
yeah, so we give thanks for your contribution here.